Okay. Hello, everybody. Samantha here. Samantha Gambles Farr, the chair of the Impact Committee. The time is now 1 o'clock, and we're going to get this meeting started. And so I'm going to call this meeting to order right at 1 o'clock. Right now, we are going to have a call to order and roll call for the purposes of attendance. Samantha Gambles Farr in attendance. Dr. Edward Ray.
I'm here, thank you.
There we go. Dr. Andrea Espinoza.
Present.
NP Jan Johnson Griffin.
Present.
NP Kevin Maxwell. NP Sally Pham.
Present.
And public member Betha Schnell. I see Betha on the call, but I didn't hear her acknowledge present.
If she said present, I read her lips to say present, but I'm not able to hear her. Do you have any audio issues, Betha, or are you able to come off mute? No.
Okay. Can we count that as present?
She is, we can count her as present because we see everything going, but we will need her to try to continue to work on audio, maybe join by phone or something. We can elevate the phone or something.
Okay, perfect. Thank you.
Okay.
Okay, we do have a quorum at this time. Moderator, will you please go over the general instructions for the teleconference meeting, please?
Good afternoon. This is the BRN moderator. I will be moderating the meeting. To facilitate public comment, we will be utilizing the WebEx question and answer feature. When the committee reaches a point in the agenda at which public comment is appropriate, the question and answer feature will be turned on, and members of the public can indicate they would like to make a comment by inserting the phrase, "I would like to make a comment," in the question box, which is typically in the lower right of your screen. I will then call on the individual and unmute their microphone. The individual will have 2 minutes to make their comments. I will not give a warning as your time approaches. I will mute your microphone and it will announce that your time has exceeded the time allotted. I will then proceed to the next member of the public who has a comment. We will also query our in-person location here at BRNHQ if there are any comments there. Please note that the question and answer feature is being used only as a means for members of the public to represent that they would like to make a verbal comment. When your turn comes, you will be prompted to unmute. If your question can be answered, the committee will respond accordingly. When making your comment, speak about anything you believe is important for the members to know. Remember, committee members cannot address any item not on the agenda. Items not on the agenda at that moment, items that you would like to add to a future meeting, or items that would be discussed later on the agenda will be discussed at the correct times during the meeting. I will provide a brief reminder of this approach at the start of each public comment item. Finally, when committee members or BRN staff are not speaking, I would like to remind them to mute their microphone. If I detect background noise during the meeting as a result of unmuted microphones, I will mute your microphone automatically.
Thank you, moderator. We will now move on to agenda item 3, public comments for items not on the agenda and items for future agendas.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for a comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember, you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment."
Board moderator, we're waiting for public comment. Can you elevate Betha again, please?
Committee Chair Gambles Farr, there are no public requests for comments on the WebEx. We have no in-person representation here in HQ, BRN HQ. Would you like me to close this window?
Yes, please.
You.
Thank you. Um, just want to take a brief moment. Let's see if Betha can now be heard via audio, just to double check.
Can you hear me?
Yes,
Yes.
thank you so much.
I apologize. Thank you.
No worries. Technology. All right, moving right along, we are going to move to agenda item 4.0, review and vote on whether to approve the previous minutes from September 24th, 2024.
Motion to approve?
Do I have a second?
Second.
I'm sorry, was that you, Jan? Okay, yes, it was Jan. All right. Moderator, we are now ready to open it up for public comment.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in the request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Committee Chair Gamble Spar, there are no public requests for comments on the WebEx. We have no in-person representation here in BRN HQ. Would you like me to close this window?
Yes, please.
Thank you.
Is there any additional discussion from the committee needed on this motion? Hearing none, I'm going to call for individual votes. I'm
Oh,
sorry.
no, that's okay. Go ahead. Sorry.
Did you have a correction or a statement, Dr. Espinoza?
Yeah, well, just to add in a future discussion, in a minute, we discussed the transition to practice. And so maybe I would like to bring that up at some point, maybe not today, but at some point, because I'm still concerned about it.
Okay, thank you, Dr. Espinoza. This is specifically for the minutes discussion. If there's anything specific to the minutes you wanted to approve or discuss within the minutes from September
It's within the
24th.
minutes.
Mhm.
Okay, it's within the minutes discussion, but I guess that would be adding something, so
Right, any corrections that need to be
then leave it alone.
done.
Sorry.
Okay, perfect, no worries. All right, Dr. Edward Ray? I'm calling for
Oh, yes.
Okay, Dr. Andrea Espinoza?
Um, yes.
NP Jan Johnson Griffin?
Yes.
NP Kevin Maxwell? NP Sally Pham? Public member, I'm sorry, Public member Betha Chanel?
Yes.
Thank you. Myself, yes on the vote. Moving on to agenda item 5.0, information only, our report from our executive officer, Loretta Melby.
Thank you. So this is just a report out on any activities for implementation of AB 890 and now SB 1451. As you guys will see in the agenda materials and the items, we will be kind of talking about some regulatory updates that had to happen to implement SB 1451. So I'll save that update for there. But what I did want to let people know that is the application for the NP 103 has been successfully updated. It does allow for people with retired or legacy national certifications to become licensed as recognized, as a 103 NP. Additionally, excuse me, there is no longer the requirement that the provider that does the attestation be in the same category as the nurse practitioner who's completing the transition to practice hours. And the transition to practice hours do not have to be exclusive to the education and training and national certification of that NP that is doing that. So an example previously set out in regulations was that if you were a pediatric nurse practitioner, your transition to practice needed to be done providing care to the pediatric population, and that a pediatrician needed to be the one that co-signed off your attestation stating that you completed this transition to practice. That was removed through the passing of SB 1451. And with that update, those requirements for that congruency no longer stands for the 103. The practice area still stands for the 104. So if you are a pediatric nurse practitioner, prepared and educated and nationally certified, you can practice in that area as a 104 independent after January of next year. Unless of course a bill is introduced and the law is changed moving forward for the 104. So the updates were specific to the 103 kind of becoming there. So that is out, that is ready. We do have people utilizing that. And that is updated and on the license lookup and such. And so what we are doing is trying to get that kind of education out and let them know that that is what's being done. But we will go further into details with the regulatory updates that need to occur, and understanding that while the regulatory updates are happening, statute always supersedes reg. So even though it may take a year or so to get through the regulatory process, usually it's about a 2-year process, it does not hinder the ability for those changes to go into effect immediately because it is outlined clearly in statute. Any questions? Yes, Dr. Espinosa.
Yeah, okay, I'm gonna ask for clarification. I did read those laws, but so are we saying for the MP 103, it doesn't have to be in the field that they plan to practice in, or the field
Correct.
that, there's 5 fields, is that correct?
That is correct. It can be in any practice area that was removed per the legislative update.
Okay, so if that's removed, just, and I know it's a law, so if that's removed, for clarification, does that mean that a 103 could be just in the practice of orthopedics?
Yes, that is correct. A 103 can. The caveat for the 103 is that it has to be within a group setting as defined in the law. And that 103 can practice without standardized procedures with at least one or more physicians and surgeons. So they're not independently practicing as a 103. They're practicing without standardized procedures in specific group settings that are specified by law.
So, so now somebody's practicing orthopedics. Am I allowed now to practice orthopedics independently as a 104?
No. As the 104, there is a statement in the law that requires the practice area to be in alignment with the education and national certification of that practitioner. And so let me pull that up really quick so I can read the language off specifically to you guys. It is in Business Professions Code 2837.104. And there is a section in there. I'm just trying to find it really quick. Sorry. Bear with me real quick. Under lowercase c number 1, it says the nurse practitioner, consistent with applicable standards of care, shall not practice beyond the scope of their clinical and professional education and training, including specific areas of concentration, and shall only practice within the limits of their knowledge and experience and national certification. So that's where that national certification alignment comes into play, and that is for specifically the 104. And
So
we at the Board of Registered Nursing only recognize the population-focused national certifications and not various specialty certifications, because those are not regulated or controlled.
So how do we, so basically we watered down, in my opinion, the 103. So I can practice, I can do orthopedics only. That's it. And when I get out, I say, well, I can do orthopedics. I mean, that still falls technically under family medicine.
It
Right?
does fall under
can
family
park that.
medicine, and there is
So-
a possibility that they could work independently under family medicine if everything in C1 aligns.
Okay, so all the major concerns a lot of people had, which was, are we going to have specialty nurse practitioners working independently? Yet we have no control of any of the competencies other than the board certification. So that would mean if it's orthopedics, they do family medicine. But I had orthopedics. Mostly I had more orthopedics, and so I'm trained in that area. But the intent of the law originally was to increase underserved areas of underservice for primary care physicians or primary care providers, excuse me. And now we watered it down now. Now all the concerns that people have from the beginning, which was somebody practicing dermatology independently, now and likely will not increase then the primary care access, only increase the access to maybe a specialty. And if the law already changed it, well, of course the statute changed. There's nothing I can say about that. But I think that if we continue to water this down, you're going to have, as it is right now in family with our nurse practitioners in our area. I work in a full rural area. They work with specialty. They don't work in primary care for the most part. They usually move on. One, because the pay is much better, for sure. Now, at this point, no, there is such a great need for primary care, yet there isn't any increase by the nurse practitioner services to provide that additional primary care for the rural areas. So what have we done except make it easier to go into a specialty for nurse practitioners independent, which I don't think that's wrong, but that wasn't the intent of the original statute or law.
So real quick, Samantha, before you jump in, just going back to implementation of this, when it went through the legislative process, that would be where a lot of those comments should have been obviously directed. Just to clarify, our role as the BRN is what statutory language is adopted through the legislative process. Our role within the BRN is to implement as written. And so I just want to make sure that we clarify when you're saying we, and we're on an advisory committee to the Board of Registered Nursing, I need to make sure that I draw that clear definition there, that you are not speaking for the Board of Registered Nursing, that you are speaking from your personal
Yes.
professional area. So thank you
Yes.
for that. One of the things when working through this process and looking at implementation, what was clear, and hopefully this will help to provide some guidance to that, is currently your nurse practitioner that's working under standardized procedures is not limited in the area that they can work. It is, they go there based on competence, and that competence is not something that is defined or determined by the Board of Registered Nursing, and that's done through employment. That's where the competence lies. And so that safety remains. These 103 NPs are still required to work within a group setting as defined in law. And that group setting that is the employer is the one that will determine competence of that nurse practitioner in the area that they choose to work in. So the 103 ends up mirroring the practice of your standardized procedure NP, as there is not a defined area that they are limited to practice in. It is just an extension of that. And what changes is they are limited to the area, the facility that they practice in, and that they have to have one physician and surgeon with them. And so there should not, again, from the BRN perspective, there should not be any threat to public risk or harm or any increase based on that, because it's still competency based at the healthcare facility level. And they are still required to practice with at least one physician and surgeon. So hopefully that will help to kind of eliminate a lot of those fears for the 103. And that's that transition to practice kind of area. So that is something that we did look at. We looked at it as a committee here when the previous AB 890 language was introduced. There were some specific guidelines that were put in there. But with the introduction and passing of the new language, it does, for the most part, just continue the current practice of the nurse practitioner operating under standardized procedures to expand into the area of the 103 where they can do that within the group setting without standardized procedures.
But so just one more comment. So we first had the transition of practice, then the regs, or was it the statute that made it, or that made it the 103 broader? Is that correct? And broader in the scope of practice, the 103. And that everything that you said right now, I understand, and that's good. Now you have the 104, and been practicing, or nurse practitioners have been practicing. This is my opinion. Have been practicing now as a 103. But they now want to work with rheumatology. They want to become a rheumatologist. They want to practice rheumatology independently. Okay, that the competency by itself is not, whatever they get with the people that work in 103 is not going to be enough competency, in my opinion, to say now you can practice as a rheumatologist. And I don't think that's addressed anywhere. I don't think there's a way to prevent that. Now, if a surgeon is different, because the hospital is not going to allow you to practice surgery if you haven't done a residency and internship in surgery or general surgery. But so how do we protect the public so that we don't, in my opinion, that I perpetuate all these specialties going out and practicing independently as rheumatologists, endocrinologists, ones that they do fall to a degree under, I use example family medicine because that's what I'm familiar with, or internal medicine. How do we protect the public?
I think that is addressed in the current law. And so nothing within the 104 really changed. That stuff remained unchanged, and the statements in there for the 104 that says they cannot practice beyond their scope of clinical professional education and training, including the specific areas of concentration, and they can only practice within the limits of their knowledge, experience, and national certification. And it's an and national certification. It's not an or anything like that. So it is inclusive of those three. Like, you cannot break those up. Then additionally, in the section that immediately follows that, when looking at the implementation of 890 and now again at SB 1451, is it requires, again, with another term, the nurse practitioner shall consult and collaborate with other healing art providers based on the clinical condition of the patient. They give specific items that they have to be specified in individual protocols. Anything that falls outside of their competency, scope of practice, their experience as a nurse practitioner, there are guidelines that address that. And it really is very clear in there under C3 that it says a nurse practitioner shall establish a plan for referral of complex medical cases and emergencies to a physician and surgeon or other appropriate healing arts providers. And then it says the nurse practitioner shall have an identified referral plan specific to the practice area that includes specific referral criteria, and the referral plan shall address the following, which says, whenever situations arise which go beyond the competence, scope of practice, or experience of the nurse practitioner. So that has your concerns that you're raising there, Dr. Espinosa, I believe, by reading this law, has been addressed with that requirement that this referral plan is in place. So it does limit that nurse practitioner practicing as a 104 to take on any situation that is beyond their competence, beyond their scope of practice, and outside of their experience. They must have a referral plan, and it must be followed.
I'm still concerned about the competent, well, I was going to say competency. I'm concerned about the misunderstanding. When we talked about referrals in the past, it was related to referrals if something was beyond the scope, or you need to refer to the general surgeon because somebody has an appendicitis, for example. It did not, we did not look at it, oh, I'm a rheumatologist and I open my doors as a rheumatologist, and I am going to do this, this, and this, and I'm going to give the biologic medication, blah, 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 in my office, blah, blah, blah. How do we protect the public if there isn't enough accountability there because we don't do competencies, as you mentioned. And the competencies, what they might have learned may be very limited by the rheumatologists that they worked with. So
well, then it would be outside of their competency, because that specific statement says whenever situations arise which go beyond the competency. And a nurse practitioner, any advanced practice RN, any RN is required to work with inside their competence. If they work outside of their competence, we many times get complaints because that's when errors and such occur. And we would investigate and follow that process that we manage with our enforcement division. So we've always maintained that a nurse, any type of nurse, regular bedside nurse, any kind of practicing nurse, including advanced practice nurse, must only work within their areas of competency. And that competency still has to occur even if a person is practicing as a 104. That does not end when they progress to a 104. That competency is required and that must be followed.
But the competency, we're not looking at so we have to wait until, I have to wait until someone goes past or works outside their competencies to find out. So where's the ahead of time?
I hear you on that, Dr. Espinosa, and I hear the concern. I think the one place that you can find kind of some peace in is by looking at our upcoming agenda item, which is trying to find it. Sorry, I'm rushing through that here. It is covered in agenda item 6.0. And when you go into agenda item 6.0, you were able to see the disciplinary issues that are brought forth in front of our board that are specific to nurse practitioners. And you would be able to see that those numbers, even though we have about 45,000 licensed NPs in our state, that there is minimal very minimal disciplinary action that has been brought onto them. So it has a proven track record, if you look at that data, that even though there is a concern that nurse practitioners might be working outside of their areas of competence, we have the data to prove that that is not occurring, based on the disciplinary actions that are brought forth in front of our NPs.
But
Yo,
do we have the data for the 104s? We don't, and not
They
even.
don't exist yet.
we don't
We
exist.
don't have any data on the 104. We have no 104 currently practicing in our state
Exactly.
today,
I
and
know
we'll
104.
not see that
Wait,
until
how
that
many 104
happens in
Oh, I'm sorry.
January.
I'm sorry. I didn't mean to over.
Yeah, we won't have a practicing 104 until the end of January 2026.
Okay.
That will be 3 years from when the first 103 received that acknowledgement, and that certification from the Board of Registered Nursing. So when that happens, we will be tracking data that comes in and said, have we seen an increase in any issues? And we will then be able to bring that in front of this committee and have discussions. I'm sure legislatively that will be watched very closely as well. And any kind of course correction that may need to occur can occur at that point. But when you look at the statistics today that is in front of us, the areas of concern that are being brought forward, saying that nurse practitioners may be practicing outside of their competence, is not supported in the evidence that we have in front of us at the Board of Registered Nursing. So
And I
that
agree
public
with-
risk is not necessarily here at this point. Anything
Right.
could change, but today that public risk does not exist.
Right, and I have no doubts on that statistics. That I'm not concerned about that because I trust that. I'm more concerned of what we're looking at the future and how what I may need to discuss with you guys or everyone. How do we move forward to prevent that? Are we gonna, so that we don't wait till 103 or 104? The problems that come up with it. So.
Yeah, I think just keeping this standing agenda item, having these discussions is always helpful. I know that Samantha, you had wanted to speak, so I want to give you time to do that as well. But I need to kind of make sure that this advisory committee is aware, as we are limited by what we can do that's supported in statute or supported in regs. And so we do need to be mindful of that. And so even though you may have a concern where you want to address that, if that's not something that's within our purview, we won't be able to. If it is within our purview and it's not clearly spelled out in our statutory authority, we would need to enact the regulatory process. And that does take a while to do that. And then that is a very outlined and specific review process for that. And we could pursue that, but that has to be something that is discussed here, brought forward here, and recommended, and ultimately has to go in front of our board for approval.
Yeah. Thank you, Melvie. That was something that I was going to speak to, was to the spirit of the nature of the advisory committee being advisory in nature to the BRN, to the actual BRN board, and then making the final decision. However, I did wanted to speak a little bit to the spirit that Dr. Espinoza had mentioned about AB 890, and I think that SB 1451 does a great job in helping us with the what we refer to as the retired and legacy certifications. ANPs are some of the most trained, longest standing NPs that we have in our state. And prior to SB 1450, they were not allowed to transition as 103 NPs. And now they have that capability. And a large majority of those ANPs are working in primary care or have primary care positions. And so I think that this actually helps us in fitting the bill of the spirit of what AB 890 was. And so with that, I just wanted to open it up to any of the other committee members who had any questions or comments before we move on to public comment.
Just as a heads up, I don't know if you noticed, Samantha, but
Yeah, I see I see
the
Kevin
practitioner
Maxwell.
showed up, so he's
Yeah.
on and available.
Yeah, I see Kevin Maxwell. Okay, hearing nothing from the committee, I'm going to ask the moderator to open up to public comment, please.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comments. I will not give reminders your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Committee Chair Gamble Spar, there are no public requests for comments on the WebEx. We have no in-person representation in BRNHQ. Would you like me to close this window?
Yes, please. Thank you, moderator.
Thank you.
Okay, we're moving right along. Agenda item 6.0, in which we will be discussing the business and profession codes of 2837.101, transition to practice, and then the business and professions code 2837.104 and discipline. With that being said, we will discuss and have an opportunity for all three impact subcommittees to provide update on work conducted since our last meeting in September 2024. And with that, we will start with our first subcommittee, 2837.101, transition to practice. There was discussion in our last meeting regarding who that committee should comprise of. The final decision was to appoint Jan Johnson Griffin and Dr. Edward Ray to the transition of practice subcommittee. And with that, I will hand it over to my colleagues.
Thanks, Sam. Yeah, we had trouble connecting. I think we need to kind of perhaps discuss how best to convene our subcommittees. Sort of had limited information. I know this sounds kind of strange to say this, but how to contact our subcommittees. We don't really share each other's emails, phone numbers, things like that. So I reached out through the BRN, and we were only able to connect a few days ago, so we didn't have enough time. What I had hoped to do was get some of the BRN staff to go over the new laws and discuss how we could, make suggestions of changes in regulations to, kind of meet our goals and the purpose of this committee. So apologies that we were not able to meet as a subcommittee to kind of present anything to the group or to the public, especially in regards to any suggested change in regulations. But I'm hoping that between now and our next meeting, we can do that, so we can, provide some suggestions in that regard. And definitely, if there's any sort of specific thoughts that anyone has on transition to practice at this point, we can certainly discuss it now.
We can, and then I do want to let you guys know and just kind of reference you guys out to agenda item 7.0. Agenda item 7.0 is regulatory text to incorporate the statutory changes from 1451. It's not specified to the transition of practice. And so we'll be able to have more of a discussion on that so that you guys can have some input on how to kind of update that if what the updates that are put forward from our board staff do not align with how you guys think we need to be moving with this. And so we do have different from when you guys were first formed as a subcommittee and an advisory committee. We do have a designated chief of legislation, a person in the role of the designated chief of legislation, where her role is to work with me and DCA Legal to update regulations as laws change and things are updated. And so she did work with us to get that process started, to come here and have more discussion on that. In the current language right now, it is just lined up with the statute because there was a lot of things where they mandated us to remove. And so it is a lot of strike through of current language. and not necessarily many additions, but that is where that conversation can happen today in our very next agenda item, Dr. Ray.
Thank you. That's perfect.
Thank you. And just to reference back to the last meeting, I was thinking we should start calling you Mr. Ray so that there's no confusion.
That's only if we were in the UK.
Oh, okay.
Be the appropriate title.
Thank you. Moving on to our next subcommittee, 2837.104, which is our NP 104 subcommittee consisting of Kevin Maxwell, nurse practitioner, and Betha Schnell. I don't think that there's, as we're transitioning into, or as 104 MPs start in January, hopefully of next year, I'll just open that up to my colleagues to have any discussions or if you had any meetings in the interim since our last meeting.
We have not had the opportunity to meet since our last meeting.
And that's okay. That is absolutely okay. The 104 application is ready. It is not released to the public. We do plan on releasing it in time for the January 2026 opening, essentially, of that classification. The one thing that we are addressing internally with BRN staff, including myself, is the how to get the verification of the clinical hours if a DNP prepared nurse practitioner wants to have those counted towards their 3 years or 4,600 hours experience. It is going to stay in alignment with the verification process that we use for nurse practitioners to become licensed, where they have to have their academic programs, sign off and do a program verification. Because that information is specifically from the program and occurs during their nurse practitioner preparation, it will follow that same process. And so we will have a form that is developed in time for the release of that application come January, so that we can have the academic institution verify that the hours that are completed with that they want the one-to-one credit for does come from the nurse practitioner academic setting.
And Melby, would that be something that could happen when they first get licensed as an NP, or do we have to wait until they actually apply for 103 or 104 status?
That is a very good question. I don't know that we've considered that in the past. I would like to look at that. I don't know how long those forms or stuff would last, or if there's any kind of legal issues that come with length of duration of signature. I know that many times when we are looking at academic institutions, we do require the college catalog from the time that the person was in process. And because that is the contract that you guys are serving under during that educational journey, right? So we get the catalog from that time period if there's ever any concerns around any kind of preparation that happened during that time. Off the cuff, I don't see an issue with having a form prepared and signed in advance. I don't know that that'd be something that would be of concern. I would have to defer to legal, and I don't know if that's something he has right off the top of his head here either, but that is definitely something that we can look at. Reza, do you have any input on primary source verification, and if there's like a expiration if the primary source verification is done by an academic institution 10 years or so before they apply?
I don't have anything to speak on that on the spot here. Just
okay.
That we can follow up afterwards and
yeah, I think that's what I was right there with you on that. So I think we'll look into that, Dr. Maxwell, but it's not something I've ever considered in the past. So that's a great question, and we'll see if there's any legal issues or something that comes up with that, and we would have to put guidance out to that.
Yeah, I would just be worried if in the unlikely event that the school that they went to was no longer in business, if it would be difficult for them to find that information if it wasn't collected, at the time?
Yeah, it would be difficult to do that. There are, of course, various guidelines currently in place that may not be in place in the next weeks or so, where there are Department of Education guidelines out there that you are required to report that information and keep that information and have that. We do have additional requirements here within the state of California with the various CSU Chancellor's Office and the Bureau of Private Post-Secondary Education. There has to be a records keeping, even if an academic institution no longer exists, right? So that still has to be there, and there has to be a transfer of that. So that is definitely something to consider when we complete this review process.
I actually think that that's a really good idea. I actually think that when he said it, I was like, ooh, that's good, because I had a situation where my school did not actually close. Luckily, it was able to stay open, but it was a California school, but not all states require that repository of records like California does. So I think that that's a good point. Thank you for bringing that up. Any other comments from either committee member or anyone from the General Advisory Committee?
I have a question. Looking, I'm assuming discussion on 104. I'm wondering if when that application comes in, if we can request, or my opinion is, can we request the sub area of subspecialties? So they have their certification in primary care, for example, or pediatrics. And can we request the area or a subspecialty they plan to practice? Because to me would be, okay, give us an idea to an information on what areas people are actually practicing in, and even ask, are you practicing in a rural area, just to get for statistical information there. Or maybe we can just ask what subspecialty. I certainly, when I apply for my license or board certification, or they ask for my subspecialty, where do I do obstetrics, or do I do general surgery? And so I'm wondering if that, for me, that might make me feel a little better that they receive the training in that area, that they will practice independently if they decide to practice dermatology, for example.
So just to clarify the role of the BRN is a licensing entity, essentially, and enforcement and education. We do not determine competency. We do not have any oversight of where people work. We do not even have a reporting requirement for them to tell us where they plan to work unless it was set forth in statute. So there are some expedited licensure processes where they have to tell us they're here to provide reproductive assistance through abortion services, et cetera, and they could be expedited on their license. But that's the only time that we have legal authority to request or require that information. There is HCI, which is a separate governmental agency here in California that does collect workforce data. And so that is more in their realm than it is with the Board of Registered Nursing. Right now, we do have a regulation. It is 16 CCR 1482.4 that talks about the application process for the 104 NP. That was something that was developed through this advisory committee, passed by this advisory committee, and put forth through the regulatory process back in 2021 and 22, so that it was ready to go by 2023, which was our deadline for implementation. That regulation specifies what's required by application for a person to become a 104 NP. there is no requirement for telling us what specialty area or what area they choose to work in. So we are not able to collect that information today. We would have to do a regulatory update. That regulatory update would have to follow that process and be accepted. I just with, again, a quick glance at that, I don't know that we would have the authority to ask that data specifically. I think OAL might review that and say, I don't think that falls within the purview of the BRN. But what we do ask in that is there is a requirement for them to have a national certification in a population focused area.
Right.
And that is required, and they cannot move to a 104 without that. And that information is provided to us through primary source verification. So we will have on their license lookup for the 104 that they are a pediatric nurse practitioner practicing as a 104, that they are a family nurse practitioner practicing as a 104, that they are a neonatal nurse practitioner practicing as a 104. That will be on their license lookup. And that is where they will have that recognition from the board that they can practice in that area at that population focus. So that will be publicly available. That will be something that we do determine. When OPES came through and gave their presentation to this advisory committee, they did a review of the national certifications for those population focus. And they did determine that competency was there to practice independently, that exam essentially solidified that. So we are doing our public protection. We do know that they will be required to turn in their national certification, and that is what we will put out through the licensing process. Willing to consider an agenda item in the future if that's an area where this regulation needs to be updated or changed. If you wanted to pursue something like asking them where they plan to work, again, I can't guarantee that that's something that would be able to go through the process, because that is not something that typically falls within the purview of the BRN. Workforce data is typically collected through HCI, and that's where we usually get that information. And they will study this, I guarantee you, and put out all sorts of information on that. They're really good at the data that they collect and share.
Thank you.
Thank you. And finally, the discipline subcommittee consisting of myself and Sally Pham, we were sent the information regarding the discipline statistics that were spoken to in our last agenda item. And unfortunately, myself and Sally were unable to meet, but we did both review the information. Sally, did you want to start off with your opinions regarding the information?
Yeah, so the first slide, the nurse practitioner discipline statistics. So it was kind of hard to tell because, you know, you see through the years, you have 2018 to 2024, a gradual increase in just overall discipline statistic, right? But we don't know is the number increasing because there's just more nurse practitioners and the percentage is the same or not. So so it's hard for us to decipher, is it really an increase or just increase in numbers, but really the statistic is basically the same every year. And then the second slides, when we look at the numbers of the discipline, the one thing that kind of for me, that in terms of practice, and I know that Dr. Espinoza was kind of worried, like in terms of practice, but if even I am seeing the projections, or in terms of practice, it's going to be hovering anywhere from like 17 to like 30 in 2021. But I don't see it going too much. And if you really look at the numbers of nurse practitioner increasing in time, in theory, our practice or our education, one could argue, is safer now than ever, or our competency, right? Because that number is actually statistically relatively the same while the number of nurse practitioners are increasing. And so overall, I think, I have questions, but I think the trend is pretty much like we don't know about 104 yet, or even actually the 103 in terms of statistics.
I agree. And looking at that, those were a lot of the same questions that I had, because as the population of nurse practitioners continue, we are in the third month of 2025. And just looking at the trim, it looks like we're kind of on the same trim that we've always been on as far as quarter wise, unless a quarter, there's something different that happens in the quarter. And I have the same opinions that you have as far as the numbers and kind of statistically what their relevance is overall. So, and
So
we'll
I'm going to
continue
share
to
with
look at
you,
them.
I'm going to share with you a screen share here, a data point for you guys to reference when you guys are reviewing this information. So give me 1 second here. So if you guys can see my screen, let me know. I'll make this bigger if I can. 1 second here, sorry. Are you guys able to see the DCA
Yes,
active
yes, we
license
can see it.
population by county?
We
Okay,
can see
when
it.
you go into this, and this is on the DCA portal, you can select fiscal year here. And so 2016 is our earliest, and we've got last year's data. I'm sure this will be updated soon. But say I want to look at 2016, 2017, I could then select my DCA entity that is going to be Board of Registered Nursing. And then I could select the data type, the license type, and I can choose nurse practitioner. At this point, this will give you the nurse practitioner data for that year. So if you wanted to do a percentage, Sally, when you're looking at that information, you can say that this is the amount of nurse practitioners in California on that date, and we can work with that. And so you'll see active population by year, right? So we have 2017, and we can continue to go 2018. It goes all the way to 2023. So you can see that. You can also break this down and do a statewide map if that's something that you're interested to see which areas have increased or decreased. If you're looking at the rural population. So what I'll do here is pull it forward to the most recent data point that's on this web. And you can show that with the nurse practitioner license type, in many of our more rural areas here, like Modoc, Lassen, Redding, there actually has been a decrease in nurse practitioners. In Humboldt County, a decrease. We've been no change in Siskiyous in Trinity. Additionally, no change in Alpine, no change in Inyo. But all of the green areas here show that there is an increase in nurse practitioners going into those areas. So this is a really good visual if you're wondering if nurse practitioners in California are increasing or decreasing and in what areas they are. And so this is here. They have a year by year. You can take the total population. They break them out as well into regional maps along the top here. You could change to show the various changes here if you want to break that out. There is a data summary as well that you can pull up where it actually just shows the percentage of change and the actual numbers as well. It does cover the methodology, as a lot of people want to always know what the methodology is and how we get to that. And then there's a how-to guide as well. This is here for everybody to use. So if you're wanting to track the growth of any of our licensed populations or the change, you can come to this. It's up on top here is the address. It's dca.ca.gov/interactive_maps.shtml. A lot of times what I do to get to this is I'll just go into Google and I'll just do DCA data portal and it brings me right here. If I'm not remembering the exact website off of that. So you could take this data, Sally, and you could sit there and look at it and say, I want to know if the percentage of disciplinary actions is changing, right? Are we staying at a 0.05 of NPs that are being disciplined, because you are accurate. We, when I first started in this role, I believe our nurse practitioner numbers were somewhere down into the 30,000s. And I could tell you today we're pushing up against the 45,000. So the small amount of numbers that you are seeing as an increase in this chart is not reflective of an increase in percentage of practitioners. It may even demonstrate a decrease in percentage of practitioners when you look at the growth that has occurred over the last few years.
Thank you, E.O. Melby. Oh, sorry, Dr. Espinoza.
Oh, I'm
Wait,
sorry.
go right ahead, Dr. Espinoza.
Is it possible on these statistics to have them per 10,000 MPs instead of absolute numbers?
I think we
Is
can
that
do
too
a
hard?
percentage. I think we can show the absolute number and the percentage of the licensed population
Oh,
during
okay.
the time frame. I think we can correlate that. But I would hate to kind of alter the data in any way that would make it less clear. And
Well,
maybe-
so I think
Oh.
by putting the absolute number in here and putting the percentage, what that represents at the percentage of the total NP population would be an appropriate thing to do. And that's something that we can
Oh,
update
okay.
and work on.
I agree, E.O. Melby, because my concern is the perception is if someone's not reading it correctly, it may actually represent that it's actually a higher number than what it actually is.
Yeah, percentage wise, it does look like you guys are going down. It does not look like by percentage of population that the
Right.
disciplinary action is increasing. You guys have grown exponentially over the last few years in license
Right.
numbers.
Correct.
Yeah, and it just like on cursory too, you could see like 2021, there was like 25,395-ish nurse practitioners, but in 2022, there's 25,800, and you can see even the numbers have dropped. So, and then in 2023, there's like 27. So there is an exponential growth, and the amount of discipline is actually going down.
It is, and if you look at the current numbers today, so you were talking about in the 20,000s, right?
Mm-hmm.
So today we're much more than that. Today, for licensed nurse practitioners, we're sitting at 42,737 total.
Wow.
Double.
Right. We blew through the 30,000s. We're at the 40,000s at this point.
Any other comments from any other committee members?
I just have one more, just to say, looking at these numbers, I have, just for the point that I hope that no one thinks that I'm not supporting 103s, 104s, or their competencies. I totally support nurse practitioner competence. I have no problem with that. I'm just looking at the public in terms of protection and make sure that my concerns are brought up. So I hope no one thinks that I'm not supporting all this. I have no doubts that the nurse practitioners is an asset and will be an asset working independently. That's all.
Appreciate that. Thank you, Dr. Espinosa.
Yeah.
And
Any
my-
other
That's the reason-
comments?
That's the reason why we have two physicians on this board and a public member, is to get a really broad perspective and not just our own licensees kind of chiming in. So it is important to get that kind of perspective from all areas. So we appreciate you sharing that.
Thank you. Any other comments from the committee members before I open it up to public comments?
I just have a point to make, if I could.
Yes, please.
Am I correct in assuming that that final column should say 2025 instead of 2024?
Oh, yes, thank you.
I think both of them are like that.
I'm going to blame it on Sam. I already blamed Macaulay earlier before the meeting started. I'm just going to blame this one on Sam.
Blame it on me because I didn't catch it either. My brain just automatically knew that it was 2025 that we were talking about. So thank you
Right.
for catching that.
Thank you.
Any other comments? Okay, hearing none, I am going to ask the moderator to open it up to public comment, please.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Angela W. would like to make a comment. 1 second, please.
Statistics and for going over them. I just wanted to comment to go with Dr. Espinoza's comment. If you are disciplined as an NP by the BRN, out of this data set, there's a total of 419 people. If you are disciplined at all, 41% of these people that were disciplined either voluntarily surrendered their license or it was revoked for them or they surrendered it. So if you're disciplined as an NP, half of the people will never practice again. And it looks like in some of the language moving forward for the 104, that one of the requirements says that you have an unrestricted license that has never been a subject of any discipline. So it looks like if you're ever a subject of any discipline, we really intend for you to never practice again. But if you do, you definitely can't be a 104. But the point is, also going with Dr. Espinoza's point, if you go to the next chart on the discipline statistics for violation type, 41% of the violation types are practice related. I would note. And 11% of them are substance use related, or 17% of them conviction related. And so I think it's important, some of this discussion, because the public is already confused about the competency of nurse practitioners. And the nurse practitioners themselves are already confused about national provider database and what gets reported when, especially when you get reported for things that have nothing to do with your nurse practitioner work outside of work. Thank you. Thank you for your important work on this. I appreciate it.
Thank you for your comment. Committee Chair Gamble Spar, there are no other public requests for comments on the WebEx. We have no in-person requests for comments in BRNHQ. Would you like me to close this window?
Yes, moderator. Thank you.
Thank you.
E.O. Melby, do we have to vote to accept the reports for the subcommittees at this time, or is this just more of a reporting?
It's a reporting. If you guys had a motion, you can make a motion if you wanted to do anything. Where if you wanted to add or direct a subcommittee to do anything or change a composition of it, there's something you can do here. Nothing that is required. So it can be just a information only, even though it does have the ability that you could do an action. It's not required.
I was just making sure for logistics wise, there wasn't anything that we needed to.
Nothing required.
Okay, all right. Yes,
I think it would be appropriate to make a motion at this point then, just to figure out a way that we can ask the BRN to facilitate our subcommittees meeting, you know, whether it's just setting up a 30-minute Zoom call with each subcommittee, because I think it was a bit of a challenge for some of us to kind of connect with others. You know, we don't want to be invasive. We don't share our email addresses and phone numbers and things like that, but it can be really tricky to schedule that. But if the BRN kind of, basically the motion would be to ask or to discuss having the BRN actually set up subcommittee meetings so that we can discuss some of these, you know, regulation language issues. sometime between now and our next meeting.
Yeah, we
I
definitely
think
can. You guys can make that motion. That's something, what I would request is it has been noticed by myself and BRN staff that we have done reach out to various members of advisory committees that are in subcommittees, not just NPAC. So I just want to make sure that you guys know that there's like other advisory committees, and we're not getting the response from the subcommittee members. So we are always willing to help and try to schedule them, but it really does rely on you guys being responsive and giving us times where we can facilitate that. There are many times where Macaulay will send out the emails to the subcommittees, because when we're having these meetings, a lot of people say, I want to meet. And we're like, okay, great. She's Johnny on the spot. She sends the emails out, and then it's crickets. We don't hear anything from the committee, or we hear from one. And then we do follow-ups. And by the time we hear from the next member, the first member is not available anymore.
Right.
So happy to do this. Yes, you guys can make a motion. It's not required, but you absolutely can. We will do all that we can to facilitate this, but we can only do one side of it. So I do ask for you guys as committee members that are part of these subcommittees to please be responsive to the emails when they do come out, so that we can really facilitate scheduling of that.
I think we can commit to that. I think I
Yes.
want to second Dr. Ray's motion. I think it's a very important point, and I feel badly that this fell off my radar, frankly, to meet. So I would love to have a guilt-free conscience and have that scheduled for us if we could. So I'd like to second Dr. Ray's motion to have the BRN support the scheduling of the subcommittees for this particular group.
All right, I have a first and a second. Need to open it up to public comment at this time.
We'll be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, I would like to make a comment. Please remember you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, I would like to make a comment. Angela W. would like to make a comment. 1 second, please.
Oh, thank you. My quick comment and question is, I noticed that the NEWAC committee had like an email address that the public could send general questions or inquiries or possible things that they wanted to bring up to the committee in general. Is there a possibility of having a nurse practitioner type general email address that goes to this committee, please?
Yes, I'm just going to answer that, EO Milby. We do have an email address for this subcommittee. I'm sorry, for the advisory committee that's been present for quite some time. I believe it's impact@brn.gov. Am I correct, EO Milby? I'm just trying, I don't want to give the incorrect email address.
dca.ca.gov.
There you go.
Yeah.
Can we put that perhaps in the chat for the public, or is there a way
We
for
don't
them
have
to see that?
access to the chat, but we can do is when on our website where the various advisory committees are, we can update the website and include the email addresses associated with each one of those advisory committees.
I believe it's on there. I think I saw it on there, but it may not be, it may be placed kind of it needs to be more where you can see it a little bit better.
It
but
is,
there
okay. Yeah, so I did just look, it is on our website, on the advisory committees, where it does say brn.npac@dca.ca.gov. And so that is there. What we could do is maybe update the contact us section of our website to refer back to these areas in case that makes it easier.
Thank you, EO Melby. I hope that's helpful.
Thank you for your comment.
Sorry, before we move on, This is Reza, Board Counsel. I just, since we had that commenter circle back, I don't know if we still have her on, but I wanted to circle back to the initial comment that she had made, and I apologize for not jumping in at that time. I wanted to just make sure that because she was talking about some confusion and uncertainty out there, and I want to make sure that we're not adding to it. A couple of things that I heard, and again, please forgive me if I didn't hear this correctly, but one, she mentioned statistics regarding the number of individuals who either surrender their license or have it revoked. And a couple things on that. First of all, a revocation can happen by way of a default decision where the individual doesn't contest the charges. It can happen by way of a hearing that takes place where a neutral judge presides and hears both sides and issues a decision that the board then decides whether to adopt or not. But I wanted to make clear whether somebody has their license surrendered or revoked, they do have the opportunity of petitioning for reinstatement of their license after a certain amount of time. So there was a comment about not being able to practice again or something to that effect, and that's not necessarily accurate. I mean, granted, there is that hurdle of petitioning for reinstatement and having that granted, but to be clear, that is a pathway back to getting your license back if it's been revoked or surrendered. The other thing I think I heard was about a disciplinary record being a bar to becoming a 104. If that was what I heard during the comment, I would question where in the law or what's given us that impression. I'm skimming through the regulation and the statute that we have, and it doesn't really say that there's a bar like that. You have to practice in good standing during your transition to practice and during the 3 years to become a 104. But am I missing something about some kind of permanent bar that discipline action precludes you from getting that authority under 104?
And board moderator, she's available. If you can elevate her, I did see that she is not currently
you.
there. Okay, there she is.
Yes.
Thank you.
Sorry, yes, I see in the discipline in the next document. Sorry, it's the next agenda item, so I can be quiet if you like, but it's under number 13. It says proof of practice as a nurse practitioner for I can be quiet, but it says the unrestricted means the applicant was not subject to a disciplinary action by the board, including probation, suspension, or public reproval. So to me, those words read, you never had a public reproval, which which is not even probation. That means you did not survive probation, which is getting your unrestricted license, which is getting an unrestricted license again. So to me, this means if you ever touch any discipline in the Board of Nursing, that you may not apply to be a 104, which is fine with me because I think the 103, 104 is ridiculous. But the reality is with the National Provider Database reporting, you really aren't going to be able to do anything ever again anyways. That's the reality, and no one tells you that, but I'll be quiet.
No, you're fine to make the comment here. You don't have to be quiet, but I want to clarify. I do think there is a misunderstanding there.
Probably.
The provision that you're talking about, just so everyone else is on the same page, in the next agenda item 7.0, there's text for a proposed rulemaking package. And in the text of section 1482.4, now the text that she's talking about is not something that's proposed to change or really the subject of the rulemaking that's our next agenda item, but under 1482.4 subdivision A 13A, that's little a 13 capital A, that's where it talks about it provides a definition of practice as a nurse practitioner blah, 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 in good standing. To kind of cut to the chase, for Angela W. and anyone else thinking along those lines, this is not saying that if you have any disciplinary record at all, that you are forever barred from being a 104. That's not what this is saying. This regulation is implementing the requirement that to become a 104, you have to practice as a 103 for 3 years or 4,600 hours. And so what this piece of it that you've highlighted here about the unrestricted, meaning not subject to a disciplinary action, that means that during those 4,600 hours or 3 years that you were practicing as a 103 and using that time as to meet this requirement to become a 104, during that time you can't have been subject to a disciplinary order. So if you were, let's just say, for example, an NP who got certified as a 103 and then got into some trouble with the board and got put on probation, while you're on probation, that time is not going to count towards the 3 years that you need credit to become a 104. But once you're off of probation and not subject to disciplinary action by the board, then you can apply. I hope that makes sense. So it's not like a permanent bar against becoming a 104. Hope that's clear, and sorry for the confusion. I wanted to just, again, sorry for not bringing it up at the time, but wanted to catch it before it was got past us. So, but thank you for bringing up your concerns and giving us a chance to address it.
Thank you for your comment. Somebody type something in the Q&A.
Are you able to elevate them to possibly make the comment?
One
That's
second.
typically how we use that. We don't typically
Yeah.
read comments, but if they are unable to for some kind of technical issue, then I'm happy to read it. But it's always best if they're able to unmute and participate.
Sangdao Phonics Linkum. If you'd like to make your comment, please unmute yourself. There's a little box on your screen that'll say unmute me. I don't think they want to unmute.
If
Not
we
a
can't
problem.
get them off, I can read it and just speak to it.
Thank you, Reza.
Sure. Again, for the commenter, if you are able to unmute and you want to speak to your point, please do so. Maybe next time we come around on public comment. The question that was typed says, quote, once you are on probation, getting employment is almost impossible for some probationary RN due to limited resources, such as limited to no access to medical malpractice insurance or corporations not having the resources and capacity to fulfill the required disciplinary actions. Why is there not a support network for all probationary nurses to do remediation? That's the end of the quote. I think, I mean, there's probably several different, there's a lot to be said on this, and different folks may have plenty more to add on this, but just in brief, I think in a perfect world, there would be more resources and there'd be, a greater ability for nurses who are on probation and still able to work to be able to work. The reality is though, unfortunately, that not all of that is in the BRN's control. The BRN its primary statutory mandate is public protection. So when the BRN takes disciplinary action, it does so with public protection as the kind of driving motivator. It's not punitive. It's not to punish anybody or slap anybody on the wrist for doing anything. It's really for the purpose of public protection, whether that means removing someone from practice entirely or keeping them in practice, but with some probation conditions and additional oversight, or even just as low as a public reproval, which merely gives the public notice that some transgression occurred that the BRN considered to be enough to qualify as disciplinary. So it can be any of those levels, but beyond that, the BRN doesn't have control over what malpractice insurance companies do or what employers do. It's their choice, and frankly, that is, I realize it's difficult and it may sound harsh, and that's not my intention, but it's part of the BRN's job is to take those disciplinary actions, put the public on notice, and let the public do with that what it wants. And we hope that there are employers out there who are willing to look past a discipline record and consider the individual, consider the job, and give folks a chance. But at the end of the day, we're not in control of any of that. And as far as resources and things, again, there is a limitation on resources. We do have, outside of the, I don't want to say outside of the disciplinary context, but as an alternative to discipline, we have our intervention program for substance abuse issues and mental health, where there is, again, it is kind of within that disciplinary realm, more or less, but it's there is a support system there for folks who are in that situation. Granted, that's not for every situation, but I just want to acknowledge the comment. Yeah, it's things certainly could be better, but it's much of what was at issue in that comment is not in the BRN's hands.
Thank you for your comment. Committee Chair Gambles Farr, there are no other public requests for comments on the WebEx. We have no in-person representation in BRN HQ. Would you like me to close this window?
Yes, thank you, moderator.
Thank you.
We currently have a first and a second on record regarding the assistance from the BRN in assisting in scheduling subcommittee meetings. Any additional discussion needed at this time? Hearing none, I'm going to call for a vote. Dr. Edward Ray.
Yes, I vote in favor.
Dr. Andrea Espinoza.
Yes.
NP Jan Johnson Griffin.
Yes.
NP Kevin Maxwell.
Yes.
NP Sally Pham.
Yes.
Public Member Betha Schnell.
Betha is still showing present, but what I'm not seeing is her on camera or coming off mute. We do still have quorum, so it is you guys can pass it with her just abstaining, as she's not able to put in a vote at this point.
Okay, and then I will submit my vote in yay. And so with that, we will have this, we are asking for the assistance, and that motion carries. We are moving on to our next agenda item 7.0, a discussion and possible action regarding the proposed regulatory text to incorporate the statutory changes for SB 1451. Within this section, we do have language that was prepared and submitted and requested by EO Loretta Melby, and I will yield the floor to her for additional discussion regarding the language that was submitted for us to review and possible action.
What I'm going to do is yield the floor to Marissa Clark, who has joined us remotely as well, and she is the Chief of Legislation for the Board of Registered Nursing.
Thank you. Good afternoon, everyone. So as was mentioned in your meeting materials for agenda item 7, starting on page 21, I believe, you'll see an agenda item summary that contains an overview of all the changes that we think are needed to conform our current regulations with state statute, given the recent passage of Senate Bill 1451. And then there's a couple other additional clarifying amendments. As was previously talked about, the vast majority of these are removing requirements that were in there in order for us to be in compliance with statute. I broke it down into kind of the main sections that we're touching. So it's the changes to the 103 MP section and the transition to practice requirements, attestation requirements, national certification, etc. Similarly, for the 104 MP section, changes that are being made, proposed to be made to that section. And then the notice to consumer section. So that's the area in the regs that talks about the requirements for 103 and 104s to notify their consumers about being an NP and potentially referring to a physician and surgeon. There was some removal of those requirements as well as some clarification of the existing. And then lastly, it's just kind of a general NP change around removing reference to method 3, which was something the full board had voted on a while back and we hadn't gotten around to incorporating. And so we figured we're already updating this section. Let's go ahead and just do it now. So following that agenda item summary, you'll see the actual regulatory text and the proposed changes that we'd like to make to that text. Additions are going to be underlined and then deletions are going to have like a strike cross through. I did want to note one thing is that when this proposed text was being discussed at last month's full board meeting, there was a public comment asking about whether some of the language could potentially conflict with or present issues for legacy and retired certifications, and they were spot on. Going back and reading it, we realized there was an inadvertent, we were referencing an existing section, and by doing so, it could have accidentally not clarified that legacy and retired certifications were allowable, which they are under the law. So there is an additional change that is not contained in the posted text, but I'll kind of explain to you that we want to include that would just make it super clear that 103 and 104s can have national certifications that are retired or legacy certifications. And so we talked about kind of, do we amend each section to clarify it, or do we just go to the section that's cross-referenced and amend it there as a central location? And we thought that was the cleanest. So it would be a change to 16 CCR 1481. And that is the section that talks about the categories and the scope of practice of nurse practitioners. And it currently has an A, a B, and a C. And we would propose to change B, so 1481B, just to clarify and add some language in there to amend it, stating that national certification can be in one of the population focus categories established under 1481A, which is the one above, and that's where you have your family, individual across the lifespan, adult geri, neonatal, pediatrics, women's health, and psychiatric mental health. But to also add language that's saying, or it can be in a population focused category whose exam was retired before January 1, 2017 by a national certifying body that is accredited by the National Commission for Certifying Agencies or the American Board of Nursing Specialties. And that language coincides with the change that was made to statute to include legacy and retired certification. So we just want to make it super clear that your national certification can be in one of those population focused categories in 1481A, or it can be in a retired or legacy category that was retired before 2017. So that's just one additional change I wanted to highlight that was brought to our attention through a public comment, and it was spot on, and I'm glad they caught that for us. So happy to answer any questions on any portion of the text.
I have a question. Just, I mean, the text so far that we've gone through sounds fine to me. But when it's mentioned 103 nurse practitioner changes, it says removal required for category 103 applicant transition to practice, national certification, and 103 certification to align. Is this what you made the changes? Because this almost sounds, when I read the general changes, that it eliminates transition to practice completely. And so I'm presuming that's incorrect.
Right. It doesn't eliminate the requirement for the transition to practice. It eliminates the requirement that all the kind of facets have to line up in terms of the area of their national certification. So it used to be, well, currently the reg state that a 103 NP applicant's national certification, the area, the category of that national certification, the category they complete their 103, or excuse me, their transition to practice hours in, and the area of specialty of their attester all have to be the same. So hypothetically, NP would have to have national certification in adult Jerry. They would have to do 4,600 hours in adult Jerry, and the person attesting to their completion would have to specialize in adult Jerry. So it's removing the requirement that they all align. They still have to meet all those requirements. They have to have a national certification. They have to complete 4,600 hours, and they have to have someone attest. It's just that areas don't have to all be the same, and that was based on a change made in the law.
So for clarification for me, so if someone has the certification in neonatal, they can, whoever tests for them could be family medicine certification, right?
Correct.
And so it doesn't eliminate any transition to practice except for the legacy, right? For the legacy.
So, sorry, go ahead.
Oh, I'm sorry, go ahead.
No, you're fine. So the legacy aspect, the legacy and retired, has to do with the requirement for a national certification. So under the previous law, there was a provision around OPES having, or the Office of Professional Exam Services under the Department of Consumer Affairs, having to look at the current exams and like continually review the exams of the categories. And so that presented a challenge if it was a certification that had been retired, because those certifications still are active. People can practice with them. You just can't newly obtain them. So there was no new exam to compare against. So that was the logistical hiccup that we had, where folks who had one of those legacy or retired certifications weren't able to get that 103 NP certification. So 1451 made sure to clarify that certifications that had been retired previously, where that they were still active, so people who had them could still practice, they just couldn't be newly obtained, still counted as eligible in terms of meeting that national certification requirement.
So it only affects then that group, right? So that those groups, it doesn't. I think I got my answer. Sorry.
Yeah, it just makes it really clear that they are eligible to apply to become a 103, but they're held to the same requirements: transition to practice, attestation, all of that. So yeah, it just expands for folks who have a retired or legacy certification to now allow them to apply.
I have a question if I could.
Yeah.
So in the 103 section, it describes that the transition to practice hours must be completed in California, but then in the 104 that is struck through. Am I missing something? And how would that work in practice?
Good question. So what we, in the 103 section, that existing in California is still in the statute, so that didn't change. What we did in the 104 section is, when the language was originally written, the 104 section kind of just mirrored, like it was like kind of a copy and paste of the 103, because of the logic that you have to meet the 103 in order to go to the 104. However, we realized by way it was written, that means that someone had to resubmit all of the same information they had already resubmitted, and we found that to be just kind of duplicative and unnecessary. So we removed all the requirements that are tied to establishing eligibility as a 103 from what needed to be submitted as a 104. So that's why that whole section is like lined through, because we would have already verified that when you came in to become a 103, that you did your transition to practice, you have a national certification, you met all those requirements. So our attempt in lining through that for the 104 was, instead of having to resubmit all that information to us, you just have to submit that you are certified by the board as a 103. So does that help?
Yes, thank you.
Any additional questions? Okay, hearing none. Moderator, can you please open it for public comment?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in the request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Committee Chair Gambles-Farr, there are no public requests for comments on the WebEx. We have no in-person representation in BRNHQ. Would you like me to close this window?
Yes, thank you, moderator.
Thank you.
And before we move on to 8, I would like to ask the committee, is there any action that they would like to take on this regulatory language in order to either approve the way that it is written so that it may be forwarded with our approval to the board as it relates to the current language that is written? That we don't see any additional actions or any additional language that needs to be corrected or anything like that.
Sam, so I'm assuming that the BRN, his staff has already kind of reviewed this and
Right.
made suggestions as to any language that needs to change on anything that we've created in the past, right?
Correct.
Any sort of suggestions to regulatory language. But so, yeah, unless there's anything glaring that we're missing.
I don't think that there's anything glaring. I just wanted to make sure that there was no additional discussion or anything else that needed to be discussed at this moment in time as it relates to this. So if there's no action, there's no action. I just wanted to make sure that the committee had its opportunity to voice any concerns or anything. Okay, hearing no action, I think we can move on to our next agenda item. Our agenda item is 8, information only, an overview of the frequently asked questions regarding nurse practitioners and the passage of SB 1451. I will yield the floor to our EO Melby and Marissa Clark, Chief Legislative Affairs.
And I'm just going to pass the buck again. Marissa, it's all you.
Sure. So I think this one's a pretty brief one. We just wanted to highlight that based on passage of Senate Bill 1451, we went ahead and updated our existing AB 890 website that had been kind of the one-stop shop we created when AB 890 passed, that talked about kind of general information, application information, and then frequently asked questions. So once Senate Bill 1451 passed, we just did kind of a review of all the existing frequently asked questions and updated them to make sure that they now reflected the current statute, because there was some of the previous responses would no longer be applicable under current law. And so if there are any errors or anything we missed, please let us know. There was a public comment or to our reg inbox I got that highlighted something I missed, and it was super helpful. Also, if there's any additional questions that you all are hearing or you think may be beneficial, please also let us know. We're always happy to add them. We want this to be as useful as possible. So if there's areas of confusion or just things that you think it'd be nice to have on there to clarify for licensees, employers, the public, from an FAQ standpoint, we are always open to that. So happy to take suggestions now or in the future whenever they kind of come up.
Do we have an email for you, or that we can send any questions or phone number?
Yes, my email, it's very similar structure to all the others. It's my first and last name, and it's also on the website. So it's marissa.clark@dca.ca.gov. And if all else fails, you can always kind of send it to Macaulay or Lori, and they can send it my way.
Okay, sounds good. Thank you.
Thank you.
Is there anything with our public comment today about, and what Reza clarified about what exactly happens if you end up in the disciplinary process during your hours during 103 or during 104, and how specifically that would be handled, I guess would be helpful.
Yeah, I don't think we have one specific to that, but that is definitely something we could look at to just talk about what type of disciplinary action could potentially, deem ineligible. And like Reza had clarified, it would only be if it happened in that 103 period. That could be a helpful one for us to add. That's a great point.
And I believe that, I don't have the regs here in front of me, that it just needs a 3-year period
Mhm.
as a 103 that you're not. So it doesn't mean that you're permanently stuck in a 103. It just means if you receive discipline as a 103, your time starts over and you go towards trying to do another 3 years discipline free. That's my understanding. So it doesn't mean that you're permanently locked into a 103. It's that you have to show that without the guardrails of the standardized procedure, that you're able to work without the standardized procedures in those group settings without any risk, right? Without any disciplinary action. And once you've successfully completed those 3 years, then you are able to apply for the 104 status. If part of that 3-year requirement, whether you're in the transition to practice or whether you're working as a 103, if disciplinary action is obtained, then you typically go into a 3 to 5 year probation process, which requires additional monitoring, which requires additional items that must be met in order to complete that process and go back to an unrestricted license. And so with that, it doesn't necessarily show that you are progressing through that to a lower level of oversight, right? If you're running into disciplinary issues in your current level of oversight. So you have to meet those 3 years without disciplinary action to then be considered to move forward. So hopefully that helps.
Do they get credit for let's say that they did 2 years and 6 months and then fell into the disciplinary process? Do they get credit for those 2 years and 6 months once they come off? Or is it going to start the clock all over again?
I don't think that it's specifically spelled out right now to be able to answer that question, but I can talk in generalities when it comes to looking at the disciplinary process separate from this process. Disciplinary process, you start over. If you're in our intervention program and you are sober for 3 years and 6 months, and the requirement in uniform standards says you have to be sober for, 2 years and 6 months, sorry, and the requirement says you must maintain sobriety for 3 years, you break your sobriety at 2 years, 6 months, you start over at 3 years. That is a requirement for completion. The other thing that occurs when you're looking at your probation is your probation timeline is set through your disciplinary orders. And if you're on probation for 3 years or 5 years and you have specific guidelines you have to meet, that continues until you complete that. And so that disciplinary action, it kind of transcends all of your license types underneath us, right? So if you're disciplined as an NP and you're also a CNS and you have your RN license, all of your licenses are now disciplined. That disciplinary action shows on every single one of them. And so you need to clear that discipline before you then move forward. And so your 3 to 5 years of that probationary process does need to be cleared because it does say or currently under discipline, right? So you will have an extended time. What I'm not sure, and I would have to go back and we'll confer with legal on this, is if you did 2.2 years and 6 months previously, and then you're out 3 to 5 years in probation, if you only have 6 more months to complete. I don't think that that is what it is, because again, you have to kind of look at that disciplinary process. You've been now under strict supervision for 3 to 5 years. 3 to 5 years is a long time in healthcare. You may need to go back and reestablish that and move forward. And if that's not specifically clear, we'll let you know. And if it isn't, then that would be an item that we do bring forward to this committee and look at maybe regulatory language around that. So, Reza, do you have any input on that?
No, nothing additional. I think it's a little hard to answer on the spot. It's a fair question, but I do tend to agree with you based on your on the spot answer. So yeah, I think what you suggested as far as going forwards is the best way.
Okay, any additional questions from members of the committee? Moderator, will you please open for public comment, please?
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate that they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comments. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Angela W. would like to make a comment. 1 second, please.
Thank you for taking time for this discussion, because I do recognize that if you've not been a part of discipline, that you do not understand it at all, because it is not well described on the BRN website, and the information is, and I'm not blaming anyone. I'm just saying that the information is changing all the time. And when you ran into your discipline in, let's say, 2017, the information was very different than it is now. And so it is difficult to track it all. But I would like to say, can we please, as a nurse practitioner group, agendize, if that's a word, or prioritize educating ourselves about the implications of the National Provider Database? Because everything that Lori is saying, I tend to believe it. I do believe it, but I also think we're underestimating the impacts of, if you even do not renew your privileges at your hospital, even if you've worked there for 10, 12 years with no negative things on your record, and you happen to go out on disability because you have a mental health crisis, you don't renew your privileges, they still have to report you to the National Provider Database. So you still have a mark on your record. Then let's say you have like discipline and you can't start probation because you're having ECT. So you have to, or you're encouraged to surrender your license because you're on disability. You can't participate in probation. Then you're reported to the National Provider Database. These things never leave your record. And I'm learning that the National Provider Database is consulted by Medicare and Medi-Cal and insurance companies and hospitals. And so then when you worked in assisted living and maybe you want to go back and be a nursing assistant, you might not even be able to do this. And so it's not just your NP license. And so maybe you wish you would have just worked as an RN. And I'm not trying to make a big deal, but I'm saying when I became an NP, the National Provider Database was not something I ever learned about. And I was the first NP at my hospital. I was the first one with privileges. I'm just saying I don't know where I was supposed to understand these things. And I'm saying that when you're ill and and there's a lot of different circumstances, and this is not all about me, but I'm saying there are a lot of NPs that are not here because 50% of us have surrendered our license and have not all the information we need. And this
is not something I can just give up, because we need to be educated about this and we need to help other people. And so you need like a very shamed NP on your panel. Like you need someone that feels like I do, like to say these things. So I'm not saying that's me, because I can't go anywhere or do anything right now, but I'm just saying, please, thank you for listening.
Thank you for your comment.
To provide a little insight for the public as well as our advisory committees who are not familiar with the National Practitioner Data Bank. That is a federal requirement, not a state specific requirement, and not a requirement specifically to the Board of Registered Nursing. It does fall under, I believe it's the Social Security Act, and it is a specific requirement that addresses a National Practitioner Data Bank. And it does require any licensing type system to report this to a National Practitioner Data Bank. I can read quickly here. It says a National Practitioner Data Bank to collect and release certain information related to the professional competence and conduct of physicians, dentists, and other healthcare practitioners. Section 1921 of the Social Security Act, herein referred to as Section 1921 as amended, expanded the requirements under the NPDB and requires each state to adopt a system of reporting to the Secretary adverse licensure or certification actions taken against healthcare practitioners, healthcare entities, providers, and suppliers, as well as certain final adverse actions taken by state law and fraud enforcement agencies against healthcare practitioners, providers, and suppliers. And we can go on and on with that. So just that, so that everybody is 100% sure where this comes from, it is a federal law. It is not a state specific law, and it's not something that the BRN has any authority over and can do something that is in opposition of what is required federally. We do have an entity that we utilize because it does say the state entities, you have to have something set up for that reporting. We do use nurses through National Council of State Boards of Nursing, and they are our reporting structure for that. And we do report that. And in fact, it's not just for nurse practitioners. It is RNs as well. All of that gets reported through that way to that area. And that is a requirement that we must, as a licensing agency and enforcement agency, do that. That is a law that we have to abide by.
Thank you for your comment. Committee Chair Gambles-Farr, there are no other public requests for comment on the WebEx. We have no in-person representation in BRN HQ. Would you like me to close this window?
Yes, thank you, moderator.
Thank you.
If I can be allowed just to make a comment. As it relates to taking care of our community, we also take care of ourselves. And as we move into, as we work as providers, everybody who's on this call, whether you're MD or an MP, understanding the business of healthcare as well is an important aspect as nurse practitioners in the state of California now have transition of practice. And as we move into independent practice as NPs, 104s, it's very important to make sure that we work together in sharing information and work independently to make sure that we are well aware of specific regulations as it relates to conducting the business of healthcare. And that's all I wanted to say. And my thoughts are with you, Angela. Moving on to the next agenda item 9.0. We will be discussing the overview of the California Code of Regulations, Title 16, Section 1484, and proposed regulatory updates regarding nurse practitioner core competencies and preceptorship requirements. Once again, E.O. Melby and Marissa Clark, our Chief of Legislative Affairs, will be discussing this.
Thank you. So actually we'll open this and then hand this over to Marissa. So this officially approving nurse practitioner programs fell under the BRN's purview in 2019. We started our initial approval process of these required approvals. I want to be very clear, they were voluntary approvals prior to that for nurse practitioner programs. This became a requirement, and we started moving forward in that direction in 2020. As we adopted these updated regulations and started doing that review process and requiring all in-state California nurse practitioner programs to come into compliance, we realized that there were several schools that were meeting barriers and not able to come into compliance that had been practicing here, providing education to our nurse practitioners for a while. One of the specific areas that was affected is as we saw academia change and go to a more online or hybrid area, we had provisions that barred essentially some people from becoming faculty and some people from becoming preceptor. We do have a requirement that students get an RN license in California so that they can be enrolled in this program. We have a requirement for if you're doing clinicals or preceptor hours in California, that the nurse practitioner or provider that is overseeing you must be licensed in California. We held that same requirement for out-of-state nurse practitioners, which was shown to us to be a barrier. So if you were an online theory instructor for a California-based nurse practitioner program and you resided in Ohio, we required you to get a nurse practitioner license in California, even though you were not working in California or stepping foot in California. Additionally, if you were a student that lived in Ohio and you wanted to do your preceptor hours in Ohio, we required that preceptor of yours at the hospital or at the clinic to get licensed in California as a nurse practitioner. That doesn't make a lot of sense when we looked at it, when it was brought to our attention, and then we looked at it because we didn't look at it in advance, because it was written and passed and it looked good on paper. But when we looked in the implementation, we started receiving that feedback, we opened that up. And if that preceptor that is licensed as a nurse practitioner in Ohio, providing a preceptor experience to a student that resides in Ohio, then it did not necessarily make sense that that preceptor be licensed to practice in California as a nurse practitioner. So that is why we opened up this section and started that process to remove that barrier so that our in-state NP programs can utilize out-of-state preceptors where that person resides, where their student resides, and utilized online type faculty that are qualified but not necessarily licensed in California as a nurse practitioner. Yes, Dr. Espinosa?
Yeah, so online NP studies, that's include in-person clinical, or is this related to their education? I guess I don't know how the online comes into this. Can you tell me a little bit more?
So it does require in-person education for the clinical preceptor, right?
Right,
And if you've got a student that lives in Ohio that is doing online classes at UC Irvine doing their DNP program, they're doing their theory component here, and in order to complete their in-person hours, they can do it with a nurse practitioner or a physician that lives in Ohio. They can do that today. They can do that now. This doesn't change that process. What we were requiring is that preceptor in another state that already has a license in that state and is practicing in that state now has to obtain NP or even MD licensure here in California in order to precept that student in Ohio, never stepping into California.
I
So
see.
it was really kind of an undue burden that did not serve any kind of protection
Yeah.
that we were able to see. And so that's why we're bringing this language forward to change that. And so I could open it up to Marissa to discuss the specific language.
Thank you. That clarifies it. Thanks.
Yeah, no problem.
Yeah, so Laura pretty much covered it. The proposed text is in the meeting materials as well, and just clarifies that clinical preceptors and the NP students, rather than needing a California license and a license where they reside, they need to be licensed where they reside. So for most of those, that's going to be a California license, but it does clarify that if they are located out of state, the clinical preceptor and the NP student only need to have an active license in that state that they're practicing in. That's really kind of the main change it's making. This proposed text has already gone through kind of the approval process, so it's actually out for public comment right now. All of our regulations have to follow a process laid out in the Administrative Procedure Act, which kind of governs the whole long process to make sure there's ample time for public input. So it is going to be out for a 45-day public comment period, and that'll be closing on April 28th. After which time we'll compile all the public comments, and then we actually have to go through and respond to each one individually. Depending on what those comments are, if they suggest changes that make sense, we could potentially have changes to it, then it'd have to go out for another public comment period, so on and so forth, until we kind of come to a finalized language and move forward with that. So on our website, on the main page under the kind of Welcome to the Board of Registered Nursing banner, there is a subheading called Regulations. And under there, there's a link for proposed regulations. And that is where all of the documents outlining this package in terms of the proposed text and what's called the initial statement of reasons, all of that is located. And what that does is it explains what we're requesting to change and the reason why we're requesting to change it. And it also includes where you can submit public comments if you have any, or if anyone from the general public has any. So we will be accepting those through April 28th.
And so just because Marissa walked you through that, I do want to share quickly how to get to that. This is our rn.ca.gov. And then if you go here to regulations, right here in the middle of the page, you can go on to proposed regulations right here. And then that will open to this page, and here's 1484. This is our notice of proposed actions, the initial statement of reasons, the actual language, and then documents that's incorporated by reference. And so here on this section, you'll see the proposed language. The underlined, again, is what was added. The strike through, I'm not seeing the strike through. We didn't strike through. We actually just underlined. An added language for clarification, sorry. And so if there is something that you guys see that you want to make comment as an individual, you absolutely can. There is a comment process and a comment period, and that is kind of outlined here as well. If you click on the rulemaking process, you can see that we are in the process of comment, and I'm not seeing right here. Right here, the notice of proposed action. It's a 45-day comment period. And then we will review any of the comments that are received. We will respond to them, and then they do go through a review process, including we'll bring those responses back to you guys as well.
And Lori, while you had, if you had the website up, I just wanted to do a quick plug that under the join our email list on the quick hits, we do have a listserv just for regulations. So you can opt to sign up for that, and you'll only get notifications related to any regulatory changes that we're proposing and a link to all of the documents. So if you have interest just in getting those kind of specific updates, we created a listserv just solely for that purpose. Yep, right there.
Do we have any idea how many students this was affecting, or was this more schools of nursing saying this limits our ability to recruit students from other states to go to our schools?
So they weren't saying that it limited their ability to recruit, and we didn't hear that students were necessarily affected. What we heard were from the academic institutions that had previously operated in California, they had to leave California. So United States University was one of them. They left California. They were not able to maintain their on-ground location here. So they brought that information to the board. They officially left California's approved nurse practitioner program, and they're operating from their other location and now doing remote teaching to California residents instead of having a in-person location here in California. There was one other school that I'm not remembering off the top of my head, but they also came in front of our board, said they would not be able to meet the approval requirements for a nurse practitioner program in California because of that requirement, because most of their students were located throughout the nation, and they asked to be removed. They were then removed as well as a nurse practitioner academic program in California, and they are doing an out-of-state remote process as well. So really to ward off any further academic institutions having to leave because they're not able to meet that licensing requirement that did not affect any kind of public protection issues, we went ahead and updated this to make that adoption of a more hybrid learning environment accessible.
Thank you, E.O. Melby and Ms. Clark. Appreciate you guys. I guess, is there any other comments or questions or concerns? Okay, hearing none from the committee, I'm going to ask the moderator to open it up to public comment, please.
We will be opening for public comment now. Please refer to the screen share for members of the public to see how they should type in their request for comment. I've activated the question and answer feature. Members of the public can indicate they would like to make a comment by typing into the question box, "I would like to make a comment." Please remember you will have 2 minutes to make your comment. I will not give a reminder as your time approaches. I do not want to interrupt you nor cause you to lose your train of thought. I will mute your microphone and inform you that your time has expired, and we'll move on to the next member of the public. I'll pause for a moment for members of the public to type in, "I would like to make a comment." Committee Chair Gamble Spar, there are no public requests for comments on the WebEx. We have no in-person representation in BRN HQ. Would you like me to close this window?
Yes, moderator, thank you.
Thank you.
And that actually concludes all of our agenda items. And
It
so,
does.
right, good job, you
get
guys.
to go out and enjoy the sun a little bit sooner than you originally planned.
I think so. I did want to make a couple of comments. Our next meeting is slated for September 23rd, 2025, unless there is a need that is recognized to have any additional meetings in between that time. And then once again, I wanted to mention our email address, which is brn.impact@dca.ca.gov. I got it that time. I used to keep that written because I used to have to say it so many times. I wanted to thank the committee members. I also wanted to thank, of course, our BRN staff and E.O. Melby and Ms. Clark for joining us today. And with that, I am asking for a motion to adjourn the meeting, please.
So moved.
Thank you. In a second.
Dr. Espinosa is raising her hand a second.
Thank you. There will be no more business discussed moving forth. Thank you guys. Have a great day.
Thank you very much. Adjourned at
Be safe.
3:13.
Have a nice
Thank
day.
you.
Thank you.
Bye-bye.
Bye.
Bye-bye.